afternoon and welcome. This is our session on the Competition Commission's recently published paper on competition in the digital economy. This is a really timely publication from the South African Commission, as millions of South Africans have suddenly had to shift during the lockdown period to using online services to shop and connect and search. Consumers in South Africa increasingly have unprecedented access to lightning quick information and innovative online services, many of which don't require payment of a fee at all. But at the same time, regulators, academics, and politicians globally have turned their attention to competition law concerns and also other concerns like privacy concerns in the digital space. And in the last few months, we've seen policy recommendations at the European Union and European national level for new ex-ante measures to deal with gatekeepers. And just last week, the United States House of Representatives Antitrust Committee published its report on competition in digital markets after a 16-month investigation, which suggested that the power of big tech companies has gone unchecked by competition regulators for too long. But this week, the Department of Justice chief was quoted as saying that he's not ready to dump antitrust law because the United States is not yet at a place where antitrust has tried and failed. So this is a critical debate, and the Commission's paper comes at a critical time. But before we can open this debate, I would like to introduce you to our very esteemed panel this afternoon. Dr. Cristina Caffarra heads up the competition team of Charles River Associates in Europe and holds a PhD in economics from Oxford University. And yes, that is a samurai that you can see in her background. Dr. Liberty Mncube is the managing director at FTI Consulting and was previously the chief economist at the Competition Commission of South Africa. Patrick Smith is a partner at RBB Economics, and in addition to an MSc in Economics for Development from Oxford University, holds a BSc and an MSc in Chemical Engineering from the University of Cape Town. And last but not least, Derek Lotter is the co-head of the Bowmans competition team. And then, of course, we've got you, our audience, who are really important to being able to have this debate this afternoon. You will find that you're automatically muted and the chat function has been disabled, but you should please make use of the Q&A tab, which is down the bottom of your screen. Your questions will be submitted to the head of knowledge in our team, Nazira, who's joining us this afternoon as well. She'll be our facilitator and she'll select a couple of questions to discuss with our panel at the appropriate time. And finally, the webinar is being recorded and a copy will be available on our website, bowmanslaw.com, later on today. So just to kick us off and to get a sense of the lay of the land and what this paper does, I'm going to invite Derek to give us an outline of some of the main themes in the Commission's report. So over to you, Derek.
Heather, thanks very much, and thanks also to the panelists and to everybody that is attending. We really appreciate you making the time. I'm going to say a few introductory remarks. What I hope to do is just give a bit of a perspective on the paper issued by the Commission. I'm going to probably talk for about 10 minutes or so. So if you get bored, it's not that much longer for you to have to wait, but hopefully I won't be too boring. But just to kick off, as we all know, the Commission has issued a paper for public comment dealing with the digital economy. The paper is extensive and comprehensive and is, I think, on balance, a well-considered assessment and overview of the factors and issues impacting the digital economy, seen as those markets which use or connect with the internet, often running in parallel to what we know to be the industrial economy. The paper, I think, must be seen in the context of the recent changes to the Competition Act and the need to foster the participation of firms owned or controlled by historically disadvantaged persons, as well as SMMEs in South Africa, the imperative of transformation, addressing inequality in South Africa and fostering participation. The paper should also be seen, I think, in the context of broader international debates regarding competition policy that are occurring, where efficiency is no longer seen as a positive outcome in all circumstances, where consumer welfare is no longer the only focus of competition assessments, and the structural nature of markets have become to be seen as more relevant to such assessments. The paper notes and emphasizes the need for inclusivity within the South African economy and the vulnerability of small firms as markets change and as perceived incumbency advantages, data accumulation, network effects are seen as establishing and causing markets to reach certain tipping points beyond which market entry may be excluded. While the paper notes the importance of balancing the need for inclusivity and fostering innovation, the paper strongly supports the need for active intervention in a number of areas, as well as scope for legal presumptions, which I found to be quite interesting, that conduct in relevant markets may be problematic, with an onus on the firms involved to justify the conduct in question. Now that's something I think we can debate a bit more later on. The paper recognizes that many markets in the digital economy may be two-sided or multi-sided in nature, with potential exclusionary practices which may range from most favored nation clauses to killer acquisitions, and where leveraging and conglomerate effects may arise, whereby firms may be able to exercise market power to exclude competition in related markets, such as on certain platforms or within certain ecosystems, digital ecosystems, whether they be based on operating systems, shared services, online retail, or social media. Some key themes relate to the potential need for infrastructure sharing, as well as data sharing as future possible interventions, especially to the extent that resources may be seen to be essential or scarce and needed by other firms to compete, and where the Commission sees itself as having jurisdiction over conduct elsewhere in the world, but which has a demonstrable effect in South Africa. In this regard, I suppose it must be said that justifiable concerns have been raised that overly vigorous and ill-considered regulation and intervention may well have innovation inhibiting, as well as potentially South Africa isolating outcomes. The South African competition regime is already seen, I think, somewhat unfairly from my perspective at least, as being unpredictable, especially in the context of mergers and with the potential intervention and participation by government and other stakeholders, and overly vigorous intervention and regulation within the digital space should not perpetuate those misconceptions, I think. Indeed, and this is something I found quite interesting, the paper itself makes mention of threats by global firms or a global firm to cease servicing South Africa rather than be the subject of a merger prohibition or a remedy. Quite an extraordinary statement in the paper, I think, highlighting the possible concern that international players may well start avoiding South Africa rather than be the subject of potential or unpredictable regulation. In this regard, it must also be appreciated, I think, that innovations in the digital space have had significant consumer welfare enhancing outcomes by giving us all experiences and access to focused information that would have been inconceivable just 10 years ago, and notwithstanding concerns related to privacy and potential manipulations of choice. Predictability and certainty foster investment, as do the fairness and the fairness of legal processes and the substantive assessments by the competition authorities. And it has to be said, again, this is my perspective, that South Africa has a solid track record when it comes to the fairness, transparency, and substantive nature of the adjudicative proceedings and decisions. That said, it appears that the issues raised in the paper are not entirely South Africa specific, and regulators around the world are grappling with the issues, and the paper underlines the need for international cooperation. It remains to be seen if such cooperation will be achievable, especially where national interest or centric factors are becoming more evident in digital markets around the world, and where the Commission sees the digital space in South Africa as currently being contestable and requiring South Africa-specific measures. The paper notes the connection between competition policy and intervention and other forms of consumer protection legislation, such as with respect to privacy, although it is noted that these regulations ultimately are aimed at addressing slightly or very different concerns in some respects. The paper discusses the advent of big data, data-rich markets, cloud computing, and that firms use data in their strategic decisions regarding the operations as the most efficient way of serving customers, whether that be for fintech or other outcomes. Specific areas of intervention are proposed with respect to mergers, horizontal conduct, and the abuse of a dominant position. With respect to mergers, particular concerns that are identified in the paper are conglomerate effects or synergies, the removal of potential competitors, input for foreclosure and margin squeezing, the combination of differing data resources, as well as issues attaching to merger creep and partial shareholdings and cross-directorships. The paper notes that the Commission is of the view that a proactive and robust digital merger regime needs to be put in place to ensure that digital markets remain competitive, and that small domestic acquisitions by large tech firms should be scrutinized using what the Commission refers to as an updated toolkit to analyze the theories of harm more prevalent in digital mergers. The Commission considers that merger thresholds may need to be amended and the calculation of categories of mergers to be changed, with a mandatory notification of small mergers by dominant tech firms and the need for the development of a practice note on the assessment of mergers in digital markets, as well as the concurrent filing of global tech mergers, such that the Commission may benefit from collaboration with other major jurisdictions in the assessment of mergers, including with respect to relevant markets, theories of harm, potential conditions. The paper notes that conditions agreed in other jurisdictions may apply equally in South Africa, and we are involved, in fact, in mergers which were small mergers in South Africa, which have been asked to be notified and are being assessed by merger authorities around the world. When it comes to horizontal conduct, the paper discusses potential harm related to the use of algorithms and the like to set prices and lessen competition, either as per se unlawful cartel conduct or as a mechanism to facilitate parallel conduct between competitors, which lessens competition. In this regard, the paper notes that one of the challenges faced by the Commission in relation to cartel investigations is the lack of the requisite skills for cartel detection using data analytical tools rather than leniency programs, as has been the case in the past, and that the Commission aims to address this by developing appropriate tools for detecting digital cartels and assessing the effects of agreements amongst competitors, especially through collaboration with other regulators, which is a constant theme of the paper. One of the things that really runs through this paper is international cooperation with other regulators. Coming towards the end, when it comes to market conduct and the abuse of a dominant position, the paper notes the perceived implications of under-enforcement, especially in developing markets and in circumstances where markets are seen by the Commission as tipping markets, those being where there is a likelihood for the rapid expansion of one large dominant platform within a particular market. The paper raises the concern that the current legislative and regulatory system may not be suitable given the challenges in regulating digital markets, and suggests that current onuses, and I mentioned this before, current onuses on the regulator be lessened or done away with, and that the preferred position may be for a reverse onus in certain circumstances where dominant digital firms may have to demonstrate why certain conduct is net efficiency enhancing or not restrictive of new entry, which appears also to be aligned, if I understand things correctly, with proposals in the EU. And Cristina, you may have a comment on that. Central issues in this context are seen as network effects attached to the accumulation of data as the basis for market power, accentuated through the use of vertical restraints and the like. In this regard, the paper notes the primary strategy of the Commission will be to use competition law to proactively regulate domestic markets to preserve contestability by mapping the digital landscape in South Africa, initiating investigations into prohibited practices under the Competition Act, issuing guidelines as to when dominant firms may be seen to be abusing their dominant position, akin to the recent buyer power guidelines that were issued by the Commission, and instituting a market inquiry into digital markets aimed at addressing barriers to entry and participation in markets, especially for SMME firms, and firms owned or controlled by historically disadvantaged persons. The paper mentions that the Commission may launch digital markets inquiry this year or next year. The Commission also intends to track foreign cases against the global players and to proactively initiate complaints where conduct is likely to be similar locally. The Commission intends to cooperate with other jurisdictions that have undertaken investigations. From a broader telecoms regulatory perspective, the Commission's position, and this is a good one, I think, is that rules such as with respect to licensing and the like should be applied equally across the board amongst competitors, geared to leveling the playing field and reducing regulatory barriers to entry and expansion. In creating an exclusive digital economy, the Commission recognizes that it must collaborate with other regulators, both in South Africa and abroad, especially as regards the use of personal data. And then finally, the Commission intends to collaborate with other regulators to ensure the digital infrastructure becomes more affordable and widely accessible, and that personal information is protected. So I hope that gives a not too quick an overview of the paper, and I hope that's helpful. So Heather, back to you, if that's okay.
Thanks, Derek. Lots of issues to consider there. We thought we'd focus this afternoon mainly on mergers and abuses of dominance. So I'll ask Liberty to pick it up there and give us his thoughts on the merger section. Thanks, Liberty.
Thank you, Heather, and thank you for outlining the paper, Derek. I'll start from where you've left. And as you've said, the paper makes a claim around under-enforcement in mergers. So I thought I'll start with the question of, has there been under-enforcement of mergers in South Africa? As you would all know, a majority of mergers do not raise competition concerns and are routinely approved without conditions. To see this, think of the tribunal's record on decided mergers. Only 13 mergers have been prohibited by the tribunal in the past 20 years out of a possible 1,600 cases that it has decided on. Most mergers are routinely approved without conditions. I would argue that this would hold true even in digital markets. The Commission's paper states that 87 mergers have been notified at least to the Commission in digital markets. Only one merger has been prohibited and 82 mergers have been approved without conditions. But it doesn't give a time reference for this claim, or neither does it give you a sense of growth in the digital markets over time. So that's not referenced, and you're not sure whether, of the 87, which of these mergers happened in 2000 when digital penetration was very low. Then the Commission cites the Furman report and other reports. But if you think about the Furman report, it uses careful language around likely and suggesting when it references under-enforcement or the risk of false negatives. The Commission takes a similar approach of suggesting that there may be under-enforcement. The fact is that it has not been proved that there has been under-enforcement, and many more mergers, or that many more mergers should have been prohibited in the digital markets. No retrospective studies have been done looking at the past. And even if it can be proved, the fact remains that whether there have been some false negatives, that does not necessarily imply under-enforcement with reference to some optimum level of enforcement. So if we are to look back at the past 10 years, the Commission cites a number of cases, but doesn't discuss them in sufficient detail for the reader to make to interrogate the claim. So let's start with Kalahari Takealot Kalahari merger in 2015. The merger involved two of the largest online retailers. The Commission approved the merger subject to conditions on public interest. There was a horizontal overlap in relation to online retailing of consumer goods, and the combined market shares were high. But however, the Commission's own investigation on consumer patterns at the time suggested that brick and mortar retailers were constraining each other. and that there was a lot of once-off customer purchases. But the measure did raise public interest concerns in respect of employment, and conditions were imposed. Then the second measure, a year later, on Microsoft and LinkedIn. This was a global measure in digital markets with a particular focus on social networking and off-premise cloud services. In South Africa, much of the focus was whether the cloud service, whether there was any exclusionary conduct in relation to cloud services. The investigation at the time revealed that this was unlikely. There were no incentives for such a strategy. In relation to the big data issues which had arisen in Europe, these were not seen as a huge concern for South Africa. And the measure was approved unconditionally, largely because Microsoft and LinkedIn generate relatively low revenues from South Africa. Then you had the Facebook WhatsApp measure being notified. That transaction was not notifiable in South Africa because WhatsApp did not generate any revenue. And the measure did not raise any big issues in terms of competition concerns in South Africa, although it was debated globally. In 2017, you had the measure between MIH and AutoTrader. The concern was that the merged entity would command a significant market share post-merger, that the barriers to entry were high. The Commission's own investigation at the time found that there were a lot of, so the customers had countervailing power, could negotiate on pricing, and could switch from one service provider to the other. And it found that there were no competition concerns and approved it unconditionally. The measure which was prohibited is the MIH We Buy Cars measure. This measure is discussed in sufficient detail in the Commission's report. There were two concerns. The first concern was about potential competition, and the second concern was about the combination of data sets. On the first concern on potential competition, there was a lot of documents to support the claims. And as I said, the measure was prohibited. So the Commission, in respect of these measures, I'm not sure that one can sufficiently claim that there's been under-enforcement. Then the second issue that's raised in the Commission's report is, do we need a more robust assessment? The Commission's report correctly first states that acquisitions of startups by established tech giants do not always meet the turnover thresholds that trigger a major review. Yet these transactions may be, in terms of their value, may be more important and they may need notification. And then it references other countries where value-based thresholds have been introduced. I have two observations on this. First, as acknowledged in the Commission's report, the Commission may require parties to notify small mergers within 6 months. Second, the Commission does not require parties to notify the Commission does require parties, to notify small mergers if at the time of entering into the transaction, the parties were under investigation for an abuse of dominance, horizontal restraints, and vertical restraints, or if at the time there's been a referral to the tribunal, or may request a notification of small mergers in priority sectors. So I don't think you need to change the thresholds. I think you can just easily extend what you're currently doing by extending the requirements for notification even for small mergers in the digital sector. So I do not see the value of value-based thresholds given the South African setup. And I would be wary of the real danger of wanting to adopt trends without really looking at whether the infrastructure South Africa does allow. The Commission report, though, correctly identifies theories of harm that could be applied to mergers in digital markets, but does not discuss efficiency explanations for mergers in digital markets. I think this is an important blind spot. Mergers between established tech giants and startups can generate important synergies and efficiencies. Technology acquisitions normally lead to the target's integration into the acquirer's ecosystem to provide complementary services, rather than the killing, or in the case of killer acquisitions. Similarly, startups may either want to monetize their base, or they may want to be, or hope to be acquired. So the acquisition by large tech firms of small firms may be an important exit strategy, incentivizing private financing of high-risk innovations. I think it's a blind spot that the Commission doesn't discuss efficiency reasons where that motivate mergers, but it has and correctly identifies the anti-competitive theories that relate to the digital markets. I think it is correct to point out that concerns arise when mergers prevent in concentrated markets, when mergers prevent competition in concentrated markets, in situations where mergers in adjacent markets harm downstream rivals or raise barriers to entry or prevent potential competition. That's correct, and the paper correctly identifies these theories of harm. To assess mergers involving incumbents in digital markets, the competition authorities have to predict the evolution of the target firm absent the merger, which is particularly difficult when, as in digital markets, the targets are very young firms. Where a merger involves the acquisition of data sets and specific data resources held by the target firm, this can be pro-competitive, but it may also be may also raise foreclosure concerns, as was in the prohibited merger in South Africa. But it would be a mistake to assume that the access of big data alone should be presumed to create market power or barriers. There are many, I can give examples where this may not be the case. For instance, some data may be available and can be replicable. In other markets, you have multiple firms that collect data and use data without concerns or foreclosure concerns. And then some data can also become easily obsolete. So it's necessary to determine whether access to data will create competitive concerns on a case-by-case basis, rather than just having standard rules. So the competition authorities in South Africa have dealt with cases in the digital markets. I started by raising a few, using the current framework, which provides all the necessary tools. In my view, I don't think the South African merger control laws contain broad rules which can be applied to a wide range of digital markets, including markets that involve big tech firms. So the existing frameworks already consider non-price competition, which is always a plus in digital markets. Then, that said, I think the competition report presents several proposals that have been advanced for stricter merger policy in digital markets. The idea that a merger with a uniquely likely future competitor should be presumed unlawful is not in itself controversial. The problem, of course, is determining that situation of a uniquely likely future competitor. In digital markets, this is not always easy, because business models are extremely difficult to predict, including the evolution of these markets by the market participants themselves. But the paper raises interesting issues around creeping mergers, which I seem to get where they're coming from. So suppose a dominant digital incumbent acquires 20 firms, each with a market share of 5%, with a 5% chance that someday it would compete against the incumbent. Much of the debate in this area has to do with disagreement over the threat of the upstart in relation to the incumbent. If the question is whether it is probable or likely that the individual firm would have, or an individual firm would have directly challenged the incumbent, the answer may be no. But at the same time, if you look at the 20 acquisitions collectively, there is now a 64% chance that at least one of those firms would have grown to challenge the incumbent, but for its acquisition. Looking at the individual acquisitions may miss, the forest for the trees. So I seem to understand where the Commission is coming from when it talks about creeping mergers and the need to do a practice note around creepy measures, although that won't be limited to digital markets. I'm not sure how I'm doing on time, but if I have 1 or 2 minutes, I may just want to talk about one issue that the Commission, that arises out of the Commission's paper around reversing the burdens of proof. I think there is a huge asymmetry in resources between tech giants and competition authorities. There are asymmetries in terms of information and expertise between merging parties and the Commission. Then the argument that reversing the burden of proof would raise the bar for merger approval and reduce the number of killer acquisitions. For me, that argument raises important opportunity costs, and the shift to such an argument may be significant. It may create a strong bias towards the Commission's position and may set a very high bar for merging parties that want to notify or that want to modify mergers. So let me end off by just talking about concurrency, because the paper raises important issues around concurrent notification between South African authorities and other authorities. I think it's important to say that already South Africa has signed a number of MOUs dealing with how they will cooperate with the BRICS countries, with the European Commission and others. I think that avenue may be important in trying to get all the authorities to decide in a similar time period measures that are global. Let me end by just, let me end here. I think I've touched on most of the important issues I wanted to talk to. Thank you, Heather. Over to you, Beck.
Thanks very much, Liberty. Some very interesting points there. Patrick, do you want to touch on some of the issues coming out of the abuse of dominance proposals?
Yes, thank you very much, Heather. And thanks to Heather, Derek, the Bowmans team for the invitation to speak with you all. And I understand there's quite a mixed audience, so I really wanted to go through 10 minutes or so of observations on abuse of dominance, and really probably 6 key topics. And it's really for further discussion and debate, but to try and open these up. I wanted to start with the context, which I think is correctly at the start of this paper. I think it is quite broad, and it's probably a bigger set of challenges than competition can solve. But when you go to the standard triple challenges facing South Africa of poverty, unemployment, and inequality, these are dire. They were dire before COVID. And that context is very important when you think, what can competition possibly solve? I think competition, in particular, its output expanding, quality improving, price falling nature of competition can help somewhat on the poverty aspect. If competition is, again, leads to further investment, and investment is allied to job creation, it might help on the unemployment and partially on the inequality front. But the statistics are pretty dire. I mean, South Africa had more than half of its population below the poverty line pre-COVID. About 14 to 15 million South Africans were below the food poverty line pre-COVID. About 100 under fives pass every day, the majority due to malnutrition or comorbidities. That's pre-COVID. I mean, since COVID, 2.5 million people or so have lost their jobs. Think of the dependency ratios in a place like Africa. That's quite massive. Efficiency and low prices and high output are not such bad outcomes when you've got that context, and might be achievable aims for a competition policy to pursue. I think you need to be very careful about this potential disincentive effect. I'm sure Dr. Caffarra will talk about much broader debates in other jurisdictions, but particularly within a developing country context. If you told 100 entrepreneurs, we know, from business studies, only one of you've all graduated with an MBA or perhaps from some coding university, 1% of you are going to succeed. And by the way, we're going to presume against any tech giant investing in you in the future. How do you like those apples? Those are difficult disincentive apples, potentially. I'm just raising this as a balancing effect. But I think if we go one more point on the context into education and informed citizenry, which is an essential part. I mean, looking around at election fights around the world, we might argue that informed citizenry doesn't exist anywhere. But in South Africa, that's going to be a critical part of this digital economy, making the digital economy work well. Inform people and hope that they take some agency with their data, with their privacy, with their with their choices and their preferences. However, on that point, you may well find that big tech, whether big is defined locally or globally, might be pretty aligned to the government. Big tech probably does want a higher educational base than you have in South Africa. My son is 10 years old, and everyone knows the stats. I think 78% of 10-year-olds in South Africa are not nearly as privileged as he is. They can't read for comprehension in any language. Now your Googles, your Amazons, your Facebooks, no one wants that to be their consumer in 10, 20 years' time, because they just can't consume fully within this digital economy. But I think that's enough on the context. That I really wanted to come on to abuse of dominance. And what is abuse of dominance? Well, in a sense, in a legal sense, it's very simple. In an economic and a jurisprudential sense, like what's this big body of law, and probably the most complex part of competition policy, it is very complex. The law is very simple. I mean, in Europe, an abuse of dominance is an abuse of dominance. It may consist of various other aspects. In South Africa, they've spelt it out a little bit more. Abuse of dominance might be exploitative. It might set high prices. That doesn't seem to be the case in most of tech, but it may be exclusionary. It may prevent competition. So abuse of dominance has always been a relatively simple context and concept, and then applied in a number of differentiated ways. And effectively, it's a balance. You don't want to take away the prize. That is the whole incentive to compete. So you don't want to punish firms for winning the race, but you do want to punish firms who harm the process by which they won. And that's always the balance. And I think the Commission has done a good job here in recognizing that balance, the importance not to harm that process as well. Destroying investment incentives is the prime one. So I think the Commission has done a good job in identifying that balance, which is critical. One of the big debates, if I move on to my third point, that has come up is, what is this goal? Is it pure efficiency? Is it pure consumer welfare? I don't think that's ever been the law. I mean, I defer to the lawyers on the panel, but I don't think economically that's the right test either. I do think competition is this healthy, dynamic process of rivalry. And I think when seen in that light, the law, which is always in terms of competition, not in, consumer welfare standard, I think that makes good sense. I think this recharacterization of what competition might be, and maybe 20 years ago, we just thought, well, I can precisely quantify it, and it is this price level, or it is this level of consumer welfare. I think these broader conceptions of competition can be helpful, but I think they've always been understood in the law. So if you look at price or output, that's something you can precisely quantify. When judges then are faced with quality as a dimension of competition, that's something they can understand, but it's extremely difficult to weigh that up against price output. So people, particularly those educated in the 70s, or many judges these days, will love the tractability of that sort of Chicago school tractability. I can add this up and I can feel I'm there on price or I was there on output. Now, ask me to weigh up a loss of quality or a loss of innovation against that output. That's very difficult. But I don't think it's necessarily a problem with the law. I think it's a problem with the jurisprudence developing. How do you take into account innovation? How important is quality? So I think these are important debates, but I think the frameworks are there. Perhaps we just need the case law and working out, putting flesh on these bones of what are these other elements of competition. But I think a broad conception is going to be essential as we move into the digital space. We all know the challenges. You can't talk about price with a Google, with a Facebook. There is none. So you need these broader conceptions. The fourth point I want to talk about is a couple of the very, very high-level economic debates that have been raised in this context are around tipping markets, network effects, even conglomerate effects. I think these are, you can easily see why they lead to, if you like, a large market share. I think we again need to be mindful of the balance here. Yes, they can lead to one firm getting a bigger market share, but why is that? Because there's a positive effect there. I want to be on the network where my friends are. I don't want to be forced to be on 10 mini Facebooks where only a tenth of my school friends are. I simply don't have time. And so I think that's, whether there's a network effect, a two-sided market. It does sound a bit scary to a non-economist sometimes, but it's inherently, there are huge efficiencies in having two types of operator meet in one market. So there are efficiencies there. So again, when policing these things, I don't think it's wrong to investigate them or to investigate the tipping nature of some of these effects, but they're there for an efficiency reason. Similarly to conglomerate effects, I know this can go too far. There can be leveraging of power from one market to another, but there is also a reason why there are conglomerate effects are possible. There can be efficiencies of putting multiple multiple activities within one firm. The next point, to get a little bit more specific on data and in this digital space, I think each of the reports that have been cited, the Commission report doesn't do it as explicitly, but the Furman report, so that the audience knows, there are 3 big reports you should probably read after this. Read anything any of the panelists have read, but definitely read the Special Advisor's report to the European Commission. I think that's very helpful. Jerry Nadler, as you know, from the impeachment fame, he heads this Senate Committee on the Judiciary, and that's the report that just came out in the US. That's Is Big Tech Bad? And there's the third report, which has been mentioned, the Furman report, F-U-R, there's no H in his name, he's a Harvard prof, and he wrote a report for the UK. So UK, EU, US, read those 3 reports, and I think each of them recognize these debates are complex. We can't just say, well, data is the reason for market power, therefore we should regulate data. Data doesn't mean anything sufficiently precise. So I just wanted to, again, to scratch at the surface of this debate. I know Dr. Caffarra could, teach us all for weeks on this debate, but to give 2 very simple examples: data portability, which is an idea analogous to number portability. Many economists who might disagree on lots of things, I'm sure could agree there may be a role for that. I want to check out of Google ecosystem. I want to check into DuckDuckGo. I want to check into Yandex. I want to check into, if there were other competitors, I want to check into Bing. I want to take ownership of my data and move it. However, if there is data that has been gathered by a tech firm due to its investments and due to perhaps to its innovation, at least in part, there is a debate. I won't tell Dr. Caffarra there's only one answer to it, but I think there's a debate over whether you should just force open access to that. And I think there's an additional aspect. So Derek very helpfully started by saying, well, there's a fear that if you imagine that Google's in that position and they say, well, you've, at least partly due to your innovation and investment, you've got a lot of data on people, that gives you an advantage. Now, the fear Derek mentioned had been expressed was, well, Google says, well, if South Africa is going to regulate me too hard, I'm done. However, I think particularly in a developing country context, we should think of the other fear, which is, what if Bing says, well, South Africa is going to give me free access to Google's data. I'm done innovating in South Africa, maybe not globally, but in South Africa, getting South Africa specific data. Now, I realize there's at least a debate here of the disincentive effect if you were to give that access. I think there's a reasonable debate. Other people might think there's a decided one in each way. I think the final point I wanted to come on to briefly, to open up the discussion and highlight some of the points for the debate, is what is an abuse of dominance and what are the provisions that we've got? As I say, there's a simple concept, but actually there are different standards to all sorts of part of abuse of dominance. So all the competition practitioners on the call will know there's access to essential facilities. There's quite a high standard for defining an essential facility, but if you deny someone access to an essential facility, you're toast. If it's just a normal input that many other people could provide, and you engage in input foreclosure, you don't provide it to someone in order to harm the process of competition, there may not be such a high standard in defining what's an important input. It's not essential, but it's important. But there may be different checks and balances and safeguards on those provisions. So I think the abuse of dominance provisions, there's a simple concept and there's a differentiated set of standards. I think it is a sensible debate as to whether or not the onus in those standards might be changed. We might have reverse onus, as we could possibly do, I defer to the lawyers, on excessive pricing in South Africa, or reverse onus after a prima facie case has been shown. And there is a debate you could have. I think alternatively, as I started with, is you might say maybe the jurisprudence just needs to develop and we need to redefine and re-argue in actual cases what is an essential facility in the digital sphere, because it's not going to be what an essential facility was to ports or to railroads 100 years ago. It's going to be a different conception, and maybe we'll have what people think are different standards or different onuses or different bars, but I think the frameworks are there. Again, as an economist, I wouldn't favor rushing back to Parliament and changing the laws, but I do think they need perhaps a new interpretation. And the final point on abuse of dominance is, yes, we talk about abuse of dominance, and that's what the competition agencies do. That's ex post. That's after something's gone wrong. I think there is potentially a substantial role for ex ante regulation. So that's the more, I mean, if you're talking about ICASA and the CC, ICASA does more of that. So there may be essential aspects or access to essential facilities that you might want to ex ante regulate. And that can take quite a lot of the the burden of changing ex post competition laws. I think there'd have to be close interaction between those sorts of agencies, but it might be that there's a better skill set, a specialized digital regulator who focuses on ex ante regulation. The Commission, has done a good job here, but I think they're more focused on ex post outcomes. But I'll leave it there, and perhaps we can go into some of these points, I hope, in questions or discussion. Thanks, Heather.
Thanks very much, Patrick. Just a reminder to our audience to send us your questions, but I'm going to turn straight over to Cristina, who I think can give us her thoughts on the points that have been raised. Go ahead, Cristina.
Who was biting a tongue. So thank you first, Heather and Derek, for inviting me and for having me. Indeed, when you invited me, I said, are you sure you want me? Because I will disagree with most of what's been coming before. I mean, I'm pretty militant on these matters. I will give you an overview as to what is happening in Europe, in part in the US. But before I do that, let me do what I think is a fundamental hygiene rule whenever somebody's speaking on a panel, which is to give a full disclosure when one is operating in the private sector as advisor. It is unacceptable to take part in a panel without saying who you work for or have worked for, so that the audience can place you. So my past is that I have worked adverse to Google on a number of matters in Europe and elsewhere. I no longer do directly. I work adverse to Google for the state attorneys general in the US in the investigation they're bringing forward to Google. I never worked for against Facebook. I have worked for Amazon, Apple, Netflix, Microsoft, Uber, News Corp no more. So you can see I've worked for many, both for some platforms and adverse to others. So I hope to have a point of view that is as diverse as can be. But fundamentally, I think where I'd like to start is Patrick mentioned earlier the reports that have been published in the last 18 months. In fact, we've been buried in the last 18 months with reports from the US, from Europe, from Australia, from the UK, going through what is different about digital and why we need to think about it differently. Now, in Europe, we have moved beyond whether we need to do something about it. We are onto the how and full steam. Because in Europe, what is happening is a real tsunami of regulation, which is being written as we speak, will be published by the end of the year. The Digital Services Act, as it will be known, currently being effectively drafted in Brussels. And that will be pretty monumental and will change the dial quite a bit. Let me explain, before talking about the act itself and what it might mean, how did we get in Europe certainly to this enormous push towards regulation in digital, which is going to be certainly the next big thing. It's not COVID as such for sure, although that has given it a further sense of urgency, but there is a broad, widespread sense that while, yes, we love the digital economy for all of the convenience factor that we recognize, there is a broad and diffuse sense amongst not just politicians or academics, but citizens that in some sense the digital economy has failed to deliver on some of its promises. So before 15 years ago, if you think about it, we were faced with this wonderful nirvana of the internet, okay? Thinking about a world in which we were going to have multi-homing, differentiation, all sorts of possibilities for disruptive innovation, no switching cost online, seamless downloading. All of it was going to make our life wonderful and capable of switching between different services. And this was supposed to be preventing these markets from tipping. The reality that we are sort of faced with today is that our attention is funneled into 3 or 4 large aggregators who control in an incredible way the way we search, the way we communicate, the way we do online purchases, the way we do networking. So this kind of nirvana sort of dream we had, or expectation that the digital economy was going to unfold in this way, has not come to pass. Let's not be naive. It's not like we should look at preventing markets from tipping. The markets have tipped. Search has tipped. Search is a global monopoly. Facebook nearly. You know, e-commerce is kind of getting getting to quite a large share. And this is really kind of perceived as having serious implications, because the concern that we all have is clearly innovation. We want more innovation, we want more creativity. There is no one who genuinely, I hope, believes that monopolies drive innovation better than competition. We are faced with a situation in which the data, the reality is suggesting that technology even does no longer seem to generate the kind of widespread economic growth that it did. The productivity improvement, the growth is not what it used to be. There are studies about this. So there is a sense that we have now the persistent dominance or unassailable dominance of certain actors, and that kind of manifests itself in incredible unevenness and unfairness in the relationship between them and everyone who relies on them for their business on their platform. They continually do what is known as market envelopment, expand, swing their user base, their data into adjacent market, and essentially occupy them. And then there is this incredible issue of data accumulation. Data is not an abstract concept. Data is something which allows these giants to personalize offers in a way that is troubling. It's not just personalized advertising, that seems the kind of nice thing. We are talking about personalized healthcare, personalized insurance. It may seem benign, but it isn't necessarily so. So all of this is something which preoccupies people enormously in Europe. And in competition terms, it worries us that it translates into exclusion, into exploitation, a very big category of concerns that is not tackled properly. There are all these unfair bargains that take place. There is privacy violation, the weaponization of privacy by the digital giants as a way to, in fact, abuse competition. And then to protect the moat all the way to surveillance and worse. So the concerns in Europe are very clear. There is no one here that thinks that we should even question whether to do something about it. We are doing something about it, particularly now, as it also become clear, we're perhaps a few years ahead. Competition enforcement has failed to deliver in Europe. Antitrust has failed to deliver in this space. We have had 3 decisions on Google, and benign as they were, in the sense that they were well-intentioned, the theory of harm was good. The remedies suck. They have failed completely. And why? Because you end up with a cease and desist that allows the monopolists to design a circumvention of the remedy and basically come back with more. You say to the monopolies, bad dog, don't do it again. The dog comes back to the back door and does it exactly again. So we are in a situation in which competition enforcement, zero, zilch. Merger enforcement. We keep wringing our hands about all the eggs we can no longer unscramble, right? We have Facebook, WhatsApp, big mistake. We have Google DoubleClick, big mistake. We're about to commit the 3rd badge of dishonor, the Google Fitbit case, because we can't unscramble, but we can't block quite as much. Now, the model in this, the one with clearly leadership are the UK CMA. The UK CMA are ahead of the pack in a very big way. And they have announced very quickly a special regime also for mergers, because digital mergers cannot be looked at as mergers, even of PTV, is a different space. The theories of harm need to just be on point. So then failure of antitrust, big problem. There is also something which I think needs to be mentioned, which is the big global economy geopolitical game and the political economy story, which cannot be ignored when one thinks of Europe. I don't know how many of you follow that, but of course, with the UK having weighed anchor and drifted to mid-Atlantic with Brexit, Europe has become a German-French bloc. No one else counts for tuppence. Who cares about the Italians? Who cares about the Greeks, the Spaniards, the Dutch? No one. It's French and Germany who count. And basically what they have at heart is the industrial complex of France and Germany. There is a commissioner, Breton, who is very close to President Macron, and he's in charge of this regulation. And his big agenda is not even so much the famous GAFA, the Google, the Amazon, the Apple, and the Facebook. His big agenda is actually also very strongly on industrial data, exchanging industrial data, B2B data. So there is a plethora of initiatives that are coming also out of Brussels with Data Governance Act, Data High Value Data Set Act, Data Act. There is a huge amount. And the background is that he basically says Europe is the world's biggest industrial complex, and we are going to not make the same mistake we've done with these business to consumer platforms of giving our data in the hands of these Americans. We are going to have a cloud in Europe because the name of the game is data autonomy, data sovereignty, and all of it cannot be just kind of transported over there. So in addition to which, again, you know, it's very difficult to miss that COVID has been an incredible boon for these companies. Good for them. They've done wonderful things, wonderful services to us generally. But the reality is that you saw what happened to market valuation. There were days in May when Apple was adding to its valuation the entire value of Boeing in a day. The value, the stock market value of these four companies is bigger than all European stock markets combined. This is a real question. We have companies that are as big as the GDP of multiple European companies. And it's very, very difficult in these cases to just sort of think that somehow they need to be treated exactly, you know, like a company in a smaller market with a slightly dominant position. So fundamentally, I think that there is this big consensus. You hear, you know, the big bad law and the economic advocates essentially moan that this is terrible, but it is really, I think, a general consensus amongst regulators that this is going to happen, and it's going to be a concurrent regime of ex-ante regulation with a list of do's and don'ts. We are having various leaks of what this list looks like. No self-preferencing, no, you know, data needs to be shared. There is also talk of breakups. So this is going to be quite strong. Competition enforcement is obviously going to continue, but they're also getting an additional tool on top of what they had before to be able to look at companies even without a liability immediately assumed. So a marketing investigation like the UK, if you like. So this is certainly happening. Final point, the US. I mean, I'm very familiar with the discussion in the US. Of course, you have seen the House Judiciary Report, or you heard about it. This was published last week. That is a monumental event in the following sense. Of course, it's a report written by staff of Congress. It doesn't amount to law. One needs to write law in order for this to become binding. It isn't binding in itself, but it is 500 pages. And it's not written as a complaint, it's not written as a statement of objection. It's 500 pages saying the competition agencies have been asleep at the wheels for 40 years. They haven't done a thing. They've allowed this enormous accumulation of power to come to pass without preventing any merger, without looking into any case. So the real kind of villain of this piece are not really the companies so much. It's the agencies being asleep. And this is the big call to arms that I think is important in that document. Whatever happens with the election remains to be seen. And the real, but it is a bipartisan view as well. So it is very likely that we will see some change to the law in the United States, which won't be as radical as Europe, but it will be something as compared to the 0 via 0 that they were implementing until now. So that's my point.
Thank you. Everyone will have a chance to give you some answers or responses at the end. And we are inviting our audience to give us some questions now. And in addition, we have a poll which will pop up shortly, and all the participants will have a chance. Please do vote on our poll, and then we'll ask our panelists to talk about your answers at the end. So just in terms of questions, we had a question from Duncan McLeod at Tech Central to ask whether we think that we should consider measures to protect the news media, like we've seen in Australia and also in France. Patrick, do you have any thoughts on that, perhaps?
I'll unmute myself. Thank you, Heather, and thank you, Duncan, for the question. I do think regulatory interventions like that can have a role. I think local media in particular has been a sector that has been decimated by this change to tech. I think any intervention does need to appreciate that the world is changing. The world for local media will change, and it's difficult to just say, well, everyone else keep out and we'll keep, you know, what was this Media 24 predation case of a few years ago. I mean, I think those days are gone and will never come back. But local media, so it does need to evolve and does need to come into a different space. And I think it's then just, I think this is more likely ex ante type of regulation, because I think, again, it's difficult to point to a specific law in South Africa now and say, well, that's broken, let's fix that. I think there is scope for regulatory interventions, and we've seen some of the suggestions in France and Australia, which I think is it can be helpful. Sorry, Cristina.
No, I was nodding. We agree on one.
Liberty?
I think.
Liberty, do you want to chip in on this debate? Do you agree that data is just data, or do we need to be doing more?
I think where we are in this debate now is we all agree that data markets are characterized by network effects, which can lead to significant barriers of entry, which are going to grow over time, sort of diminishing, and that network effects are now a fact of life. And I think several markets have tipped or will tip if they have not tipped. So that leads me to a point where I think a closer consideration of data, innovation, and potential competition are important in digital markets. I don't think there is any debate over that. I think it's worth thinking about other ways to reduce the barriers to entry, and regulation is a suggestion, but also increasing a consumer's rights to control over the data that might foster some competition in terms of improving quality of services. So rights of a consumer to get access to their data, to retain their data in a usable way, so that if they want to switch, they can take it to another person, to another competitor. I think regulations permitting consumers to withdraw their data in a usable format when they want to use a different service provider may lower barriers to entry. I think the possibilities, these possibilities are outside competition. In South Africa, we're not having that conversation yet, and I think that's where we must be heading. I think the Commission document is an important start, but it needs to move beyond the competition sphere to what other regulators can do and what other legislation can help in terms of reducing these barriers to entry.
Okay, Heather, could I just clarify, just having seen a couple of comments, and again, just hopefully to smooth the debate to come. There's a couple of questions about are network effects bad in South Africa? I think that they're not necessarily different in economic nature than anywhere else. They say network effects can arise because there's an efficiency, or there's at least an externality from one person, or an external effect. So one person using a service and there's another person using a service, and they have an effect on one another, even if they don't directly interact, they don't pay each other money. So network effects are there. I think they can lead to tipping. They can be used for, and they can facilitate anti-competitive exclusionary practices. So I don't think they're necessarily good or bad. I think they do exist, and they exist in a similar way in South Africa to other countries. And very, very briefly on the next comment, someone commented, I think Patrick mentioned access to big data doesn't confer market power in and of itself. I don't think that's necessarily right. I think access to big data, access to unique data sets, access to bigger data sets than your rivals, and also a unique capability to gather big data sets that your rivals just could never get that capability. I think that can give market power. My main comment on data is that I don't think it's a one-size-fits-all solution. I do agree there are solutions required to the data problems, but I don't think there's a data problem. There's the data portability, there's access to large data sets, the ability to to enter a market because of this huge hurdle of having that data. So yes, I think data can be a barrier to entry. It can give or facilitate or exacerbate market power. I just don't think the solutions should be one size fits all. Well, we'll license data at cost or something in all contexts. That was my main comment. And it's a huge debate. But you go, Cristina.
But Patrick, that's the standard answer I hear from big tech. Oh, it is going to have enormous unintended consequences, terrible things if we do one size fits all. Who is talking about one size fits all? There needs to be solutions that are, of course, targeted and smart. No one is kind of hoping to do something clunky or stupid. And that has got to be the starting point. But surely the data mode is what generates and protects and extends the market power. Google is a company that started off wanting to, essentially its motto was, we gather the world data and make it available. No, the motto is, the reality is we monetize the world data. And that's great, but the point is that when no one has got anything comparable, then there is an enormous sort of this distance between that and anyone who can possibly hope to compete. When it is also aggravated by conduct that is problematic, tying and exclusion, that's a problem. So kind of not specific to Google, but no one is kind of suggesting to do something dumb. When I hear this discussion and I hear people saying, well, the regulation will be problematic because we're going to do something dumb. No, we're going to think carefully about how to do intelligent interoperability, we hope, and that will require the thinking about how. Enough talking about whether. We need to think about how, and we need to do how. And the how is beginning to take shape. There are suggestions out there of how you create. For example, there is a paper written by Fiona Scott-Morton in the last 2 weeks on interoperability that says, well, it isn't something that you can kind of leave randomly to some regulator, right? There are huge asymmetries of information. There needs to be technical knowledge. The model that's being suggested is the same as the standard setting organization, where stakeholders on different sides have to, under the supervision of a regulator, come up with standards and APIs and agreement on the various components. But this is a fake debate, the notion that we cannot do something that is one size fits all. No one is suggesting that. I mean, the data is the big source of the market power, and somehow it will have to be addressed. And how we address it is the question, not standing back and saying it could be a problem if we do it stupidly. Yeah, well, lots of things are stupid if you do them stupidly.
Yeah,
So that's my
4 things on which we agree. We both agree, dumb, stupid, clunky, they're all out. No, I was only trying to scratch the surface for an audience of a big topic. And there is obviously the data moat problem, which I know you're very focused on. There are other data aspects that lead to privacy, that might lead to inequality. There may be transformation aspects, but there may be other clever solutions, clever but different clever, that might be needed in each of these different areas. Yeah, that's the key point I want to introduce people to.
Yeah, and we need to stop using privacy. These debates often not today, but I take part in so many. And you have again the platform saying privacy isn't a competition issue. How is it not a competition issue when you are exploiting my data, mining it in a way that I don't consent to in order to gain competition advantage? There has to be when there is weaponization of privacy rules like the GDPR to actually not allow for access to data. So this stuff, fortunately, I think will be overtaken by the regulation because it will be clear that these kind of things will not be listened to. So I think that's one of the benefits of having moved on to the how rather than the whether, which has been preoccupying us for too long.
On the how, I think there are 2 important questions. One is who is going to do it? And then the second is, can they do it at all? So Liberty, if I can ask you, I mean, do you think that there is the need for more coordination between the Commission and other regulators? And how do we achieve that more efficiently than we've managed to do it to date?
So I know there's been a suggestion of a super regulator that has been put before the policymakers, but I don't think that suggestion has gone that far. I think it's perhaps time to think about that suggestion again. Then there's also a suggestion around a market inquiry into these issues as a starting point, in which the Commission would lead the market inquiry, but it may be very useful for that market inquiry if other regulators are brought in and actively participate. Because I think the process of MOUs has not lended itself to a useful application where the Commission and the regulators coordinate. In my view, the Commission has asserted jurisdiction while signing MOUs and concurrency, and not in the concurrency of its actions in particular sectors, including in the digital space. I don't think the MOUs between the Commission and say CASA would work. But I think a market inquiry led by the Commission involving ICASA as a participant, a mandated participant, may work. And that market inquiry must go beyond just the competition issues to think about what are the pro, and try and bring other agencies, including government departments, to thinking carefully about what is this pro-competition regulation that's needed in these markets. So I think that is the how, and I think that's where we should be heading, because as of now, we have not identified that those regulations that may need to be amended to foster competition in the digital markets. We know the limitations of competition, but we all talk about regulation, but we've not gone that far. So an inquiry would be a starting point, and the inquiry must be asked to make recommendations on regulations that foster competition.
Thanks, Liberty. And Derek, if I can ask you, are there jurisdictional problems? If one thinks about how our authorities have recently approached the exercise of jurisdiction in the Commission's Forex complaint, for example?
Yeah, absolutely. I mean, I just wanted to pick up quickly on what Liberty has said. I mean, I agree entirely. I think there needs to be more coordination. Aspects of South African consumer protection law is sitting in different places. There's a credit regulator, there's a privacy regulator, there's ICASA, there's a Consumer Protection Commission, then there's a Competition Commission. It's really uncoordinated. It needs to be coordinated. And then Liberty touched on it as well. There needs to be a market inquiry. I support the market inquiry. That's how you get the information. You get the picture of what your market looks like. And then you can do, I think, what both Cristina and Patrick was saying. You could intervene specifically, and the Commission has shown a track record of doing so, along with the Minister, for that matter. That the buyer power regulations, the buyer power interventions, also those particular to price discrimination, they are there particularly crafted to address an imperative, and it's an example of ex ante proper intervention, properly thought through, properly consulted, which I think I would support in principle. As regards jurisdiction, I mean, I think it's a more complicated thing than what the Commission likes to think. Conduct taking place elsewhere having an effect in South Africa. How that's going to occur, I have yet not got my head around. And I was just looking at the privacy legislation this morning. It doesn't have the same type of provisions as you find in the Competition Act, for example, dealing with economic activity having an effect within South Africa. It actually doesn't say that at all. So conceivably, you might enter your data into a portal in South Africa. It is stored elsewhere in the world. And the way it currently reads, the regulator has got no jurisdiction over that. And I think it just brings down to a theme that does resonate in the digital paper. It's all about coordination. How is this coordination going to occur? And I mentioned it earlier on, there are unfortunately quite national positions that are developing. You have the US having its position. You have China having a different position. You got the Huawei investigation that's about to be launched. And all of these things are frankly quite centric and not related to international cooperation. And so it's going to be interesting to see how that all pans out.
Mm-hmm.
So Cristina, having sort of heard some of the suggestions from our competition commission, do you think they go far enough? Are we missing the boat, or are there some South Africa specific issues that might suggest that we need to apply a little bit more caution in these markets? What's your view?
I mean, I wouldn't presume to comment intelligently on these suggestions because I haven't really digested them properly. I am sensitive to the need to think about context, but these are global players. And so while I understand that the same is true in Europe, the UK even couldn't do anything about any of these entities on its own because, you know, they have enough power to shut one country down if they want to. I mean, they can bounce a country off their list in the sense that, you know, as we know, Google and Facebook both threatened to just stop operations in Australia if the ACCC bargaining code was not withdrawn. And some countries are not important enough for them in revenue terms, perhaps, to be flexing their muscle. But the problem is a global one. So I agree that there is a need for coordination. A single country cannot take decisive action. We have examples in Europe, however, that are quite interesting. France has been incredibly militant in this space. They have, for example, taken numerous actions against Google in particular, using interim measures. And this is something I absolutely think is important. You have a situation in which you have a giant platform and you have somebody whose life, and this is true also of Amazon, not just Google, but there is a decision that this particular trader, this particular business doesn't conform to certain rules that are not well understood, not very clearly explained, and they are ejected. And that is a pretty terminal act for people who depend on the platform to survive, or to make commerce, do commerce. So France has been incredibly militant in applying interim measures, saying, fine, you reinstate them right now. We will investigate the complaint, and if you're right at the end, you can eject them. But don't do this in a sort of one-sided, willful way. This is to do with exploitation, it's your bargaining power. So even a single country like France can be quite effective in dealing with local issues in a forceful way. And essentially, Google in France has been taken to the courts multiple times as a result of interim injunctions. Interim measures, because no one feels they can wait 3 years to have a business dead and blood on the wall and then come to an antitrust decision. Let's kind of have that reinstated and then decide. So there are things that I think can be done locally that can have an impact on the local business community. And that the French example is one I suggest that should be really looked at quite closely for what a country can do on its own, even against a global player.
We don't have a very strong track record of applying interim measures in the complaint context in South Africa. So maybe this
but you know, Heather, it is also the case that there isn't a strong record in Europe. I mean, the European Commission has dusted down the interim measure only last year for the first time in 18 years. What I'm saying is that it is a tool that can be incredibly effective, because given the speed at which these kind of markets are evolving and developing, you know, ex-post enforcement is just not going to deliver if you care about preserving some businesses in business. So I think it's something to be thought about quite seriously on the part of the regulator.
Okay, thanks. I'm just anxious that we may end up running out of time. It's been such a fascinating debate, and thanks to everybody in the audience who sent us their questions. We haven't managed to get to all of them. We did run a poll, however, and I think it's worth having a look at the poll results. So first we asked you whether all acquisitions of companies in the digital space should be notified as a merger in South Africa. Interesting to see quite an even split there of yeses and nos. Then we asked, did you think that the new provisions in the Competition Act which restrict abuse of buyer power would be adequate to address abuses by dominant online platforms? Once again, a relative split there, but coming out on the no side, which is interesting. Then we asked you, should our authorities have greater statutory powers to address privacy concerns? Quite a few people thought yes, but also quite a few people thought no. And then interestingly enough, we asked whether concurrent regulation of competition by the Commission and ICASA, our telecoms regulator in the digital space, is that working? And a lot of people, 84% of our respondents, thought that it wasn't. And I think that's picking up strongly on the points that, that Liberty was making, that we may need to start considering a super regulator sometime soon. Okay, so I'm going to turn to our panelists again and just give you a couple of minutes to make any final comments or to raise any issues in response that you'd like to. Cristina, would you like to make some final comments?
No, not particularly, other than I thought what your poll suggested there was quite an interesting mood in favor of more enforcement, more regulation, and not less. So I do not know enough about the composition of the audience, but it does appear to be a pro-enforcement mood, which I'm pleased to see, because certainly, it is a time to do more. And I agree, we need to think about institutions very carefully, because the last comment I'll make, even in Europe, we have this great big tsunami of things happening, but there isn't a clear plan as to who is going to actually implement this regulation. DigiComp is one thing, but the regulation, DigiComp isn't the regulator. So we need to think about, is it going to be devolved to national regulators? Well, that's a bit of a disaster with 27 member states. So the thinking about the institution is important. The thinking about the remedies is important, and it's a global thinking. I mean, what I think is just beginning to happen is the thinking about the how concretely, because for 18 months we talked about the weather, so digital barriers to entry and network effects. And by the way, I agree, network effects are not efficient. They're just simply a fact of life. They are not an efficiency, it's an externality. And they can lead or may not to tipping. But that's kind of the past. We've kind of done that. We've understood that. There's nothing new there. Now, how do we deal with a market that is tipped? And it doesn't, and this is in response, last thing, to one of the questions. What would you do when these companies are, I mean, it isn't about breaking them up and creating 5 little Google, Moogle, Doogle, Frugal, Noogle, and creating that. But there needs to be some form of competition. If you only have 99% of searches performed on an engine, well, that ain't competition. There needs to be something, maybe sort of carve out some bits, which is something that we may see, or really think seriously about interoperability that does kind of work. It's really time to think about what we do exactly and smartly, not doubly.
Yeah, Patrick, any final thoughts?
Thanks, Heather. Yes, I agree. There is a big debate on the how, and it's whether it's carve-outs, interoperability, etc. I think that's a massive debate. I think I wanted to tag on another thought on the South African context, because I think the whole tone of the paper is about solving the triple challenges. It's about industrial development, and I think where I've personally written and spoken in other places, I think arbitrarily moving the obligation for industrial development from the state to individual private sector companies who their only fault is they tried to do a merger, I think that's inefficient. I just don't think those private entities are good at developing their markets, at developing SMEs, developing HDI. So I think there is a bigger role for the state there. And I'd agree with Derek. I think the Commission's 2 suggestions that make the most sense is first the international interaction, coordination, etc., learning, people on secondment. I know that already happens to a degree. That's fantastic. The second one is a market inquiry. And I think if there is this economic development focus, I think it's not just a market inquiry on where the competition problems are. I agree, that's a big part of it. The second one says, well, there are some areas that are likely contestable for local firms. I think that part is not only a competition part. That involves the rest of DTIC, the other people doing industrial development in South Africa, and working how can we find the right pockets of coders or whatever else you need in the Eastern Cape, or the Northern Cape University has some coding center, and they think there's a contestable area here, or there's a logistics function that could take away the warehousing and logistics function of some big online retail or something like that, where there are these contestable spaces, and then industrial policy really feeding into how can we develop those industrial spaces. It's a competition, people, to open up the interoperability or interactions between these different spaces, but it also needs industrial policy to come to the table. And if this is going to be an economic development opportunity, you know, identify those, be realistic about what South Africa can and can't do. I think in South Africa, it's often a capability scarcity problem, but be realistic and get other people on board. Don't just say, well, dear private sector, you're going to have to go and empower the sector and do my industrial policy for me. Thank you.
Thanks. Liberty, any final thoughts?
I would like perhaps to thank you, Heather and Derek and Patrick and Cristina. I've enjoyed the debate. I have nothing further to say. I've really enjoyed it. At some point I was watching and thinking, why don't I have popcorn?
Thanks for joining us. We really appreciate it, Liberty. Derek, any final thoughts?
I'll be very, very quick. And as I've listened to the debate, what I think I'm coming to is market inquiry needs to be done. It needs to be done. It needs to be well-resourced, independent and thorough. It needs to get the real picture of the digital market in South Africa. It needs to think carefully about the outcomes of that and what interventions might be suggested. It also needs to be pragmatic at the end of it all. I think our authorities can tend not to be pragmatic on occasion. And then it needs to think about those South African companies which have shown significant levels of innovation and what can be done to protect what the Commission recognizes is a fairly contestable market in South Africa and regulate appropriately. So those are my remarks. Thank you very much to everybody.
Yes, I'd like to second that. I know that you're all very busy people on our panel and we really appreciate your time. And thank you so much to our audience. We had a flood of questions this afternoon and some excellent questions that we just didn't have time to cover. We always end up wishing that we had another hour just to have the debate and have the questions. But we will post a copy of the session, and to the extent that some of you have asked us for links, we'll link to those on our website. But really a very big thank you to everybody on the panel for a really fascinating discussion. We really appreciate your time with us today.
Thank you, everyone.
Thank you.
Speak soon.
Thank you, Cristina.
Have a good
Bye-bye.